I was ordered by a federal judge to remove the video deposition of City Administrator Ruth Ciaba Green from my channel. They are no strangers to representing corrupt tyrants. They previously represented the self-proclaimed supermayor, Tiffany Henyard. You are a lying fat count. You are a liar and you are an expletive hunt. This is why they hate transparency, ladies and gentlemen, because does that voicemail sound like a violent threat to you? Enter an order sanctioning Reyes to a financial penalty pursuant to the court's inherent power to sanction. Hey, what's up guys? Long Island Audit here, back again with another video. In today's video, we are going to be going over the emergency motion filed by defense counsel for the city of Berwyn in detail. As most of you know, I was ordered by a federal judge to remove the video deposition of City Administrator Ruth Ciaba Green from my channel. I genuinely misunderstood a conversation I had with my now former attorney, Gregory Koulis, about the publication of the video depositions. Mr. Koulis is now my former attorney because he filed a motion to withdraw from the case after he threw me under the bus because he is terrified of being sanctioned by the court. Again, it was a misunderstanding. With that being said, I am actively looking for a new attorney in the state of Illinois to not only respond to this emergency motion we're going to take a look at, but to file appeals for the protective order and the lawsuit that was dismissed. If you are an attorney or know an attorney in the state of Illinois who can help me, write me an email at longislandaudit@gmail.com. Now let's go over this so-called emergency motion filed by the defendants in this case. Let's get into it. In the United States District Court for the Northern District of Illinois, Eastern Division, emergency motion for order directed to plaintiff Sean Paul Reyes to remove videotape deposition from his YouTube channel, compel Reyes to comply with prior court orders, and for sanctions. Now comes the defendants, the City of Berwyn, Sergeant Volante, Detective Monaco, Officer Galoni, and Ruth Ciaba Green, by and through their attorneys, Delgado Law Group, LLC. An interesting fact about the Delgado Law Group is they are no strangers to representing corrupt tyrants. They previously represented the self-proclaimed supermayor, Tiffany Henyard. Always remember, birds of a feather flock together. And in support of their emergency motion, argue. Throughout the pendency of the civil litigation, defense counsel as well as individual defendants have been subjected to persistent harassment, including threats of violence, offensive language, and barrages of spam calls and emails. These repeated attacks are traceable to Reyes' social media accounts, where he posts edited videos of workers engaged in civil service and provides baseless commentary, dragging the subjects of the videos in order to generate income. First and foremost, I have no idea how these so-called attacks are being traced to my social media posts when there have been several other media outlets who have reported on this injustice. Second, I would change engage in civil service to engage in tyranny and corruption, especially in this specific case where I was thrown in a jail cell for recording peacefully in a public building. Never forget that. And the accusation by defense counsel that I provide baseless commentary is inaccurate. Maybe you don't like my commentary because I'm exposing your tyrannical clients to the world, but that's not baseless. I'm not dragging them through anything either. I am speaking the truth, and I'm reporting on the facts of constitutional rights violations. And as far as the income, we'll get to that because the defense counsel in this case mentions my income quite a lot. In 2023, around the time the parties were engaging in settlement negotiations, defense counsel started getting a series of calls, emails, and even text messages that were extremely offensive, which were later traced back to a video Reyes had posted to his YouTube channel about the instant case and displaying defense counsel's profile in the background. This continued, and in May 2024, defense counsel received numerous offensive calls and emails from followers of Reyes in connection with Reyes' posted video of defense counsel, until defense counsel's law firm had to turn off their phones and secure the entrances of their local offices. The court denied defense counsel's motion for sanctions at that time, though the court ordered Reyes to remove the offending video. The harassment from Reyes' followers, which is directly caused by his public monetized YouTube videos, another mention of my income, has not been limited to defense counsel. During the pendency of the underlying criminal proceedings and the subsequent lawsuit that Reyes filed, Berwyn City Manager Ruth Ciaba Green continuously reported to counsel that she had been receiving violent threats and offensive messages on her work phone and email account. Unlike defense counsel, Ciaba Green and other city employees do not have the luxury of shutting off their phones and locking their doors because they work at Berwyn City Hall, a public place that is required to remain accessible to the public. Unless you're peacefully recording, then you get unlawfully arrested, right? Following this persistent harassment and threats to both defendants and defense counsel, Reyes insisted that he was entitled to record the depositions of the defendants in order to prosecute his case, pursuant to an unspecified federal rule of civil procedure. Defendants, aware that Reyes had plans for those videos that included their future harassment, objected. The parties came to an agreement that the defendants would sit for videotape depositions on the condition that they be used only for litigation and would not be posted to the YouTube channel or otherwise published on the internet. Defense counsel was specifically concerned that Reyes would use the videotape depositions to generate income for the third time, mentioning the income that I generate from his YouTube channel and his website. The use of the depositions in this manner directly violates federal jurisprudence around the country, including the Seventh Circuit. The court granted Reyes' motion compelling defendants to sit for videotape depositions, pursuant to Federal Rule of Civil Procedure 30B, 3A, and 26C1, on the condition that the defendant's protective order limiting the use of the video footage was followed. The court found the defendant's fears that Reyes intended to misuse the video footage were valid. The court finds that a protective order is warranted to protect defendants from further annoyance, embarrassment, and oppression. These are public servants, ladies and gentlemen. This is a city administrator and 3 law enforcement officers, all who conspired together to violate my rights and put me in a jail cell. And they're the ones that feel oppressed, annoyed, and embarrassed? Defendants shall be presented to sit for video depositions. However, the resulting video footage shall be used only for the purposes of this litigation and shall not be posted online or on social media or utilized outside the court proceedings in any manner. The prohibition set forth in this order shall survive the conclusion of these proceedings. Plaintiff's failure to abide by this order will result in sanctions. Posting a videotape deposition of Berwyn City Manager on plaintiff's YouTube channel on Tuesday, February 4th, 2025. Today, defense counsel again got a report from Ms. Ciaba Green that plaintiff had posted her videotape deposition to his YouTube channel this morning, and immediately thereafter, she was the subject of continued harassment from Reyes' followers. Ciaba Green reported that she had so far received 2 harassing voicemails from Reyes' followers. One, Constance Hunter, known to Ciaba Green because of Hunter's prior persistent personal harassment and violent threats towards Ciaba Green through the previous civil and criminal proceedings, threatened that she would show up to City Hall and record her. Now let's take a look at the exhibit to see exactly what Constance Hunter said to Ciaba Green. Voicemail preview. Hello, I am calling because I am a traveling photojournalist. I mainly cover sports events, but I am going to be coming to the city in the next couple of days, and I was trying to see if I would be able to record in City Hall. Just trying to see if that would be okay. I don't want anybody freaking out or anything like that. If you can call me back, that would be greatly appreciated. My name is Savion Hunter. Thank you. This is why they hate transparency, ladies and gentlemen, because does that voicemail sound like a violent threat to you? It sounds like a peaceful photojournalist asking to come film a public building, and they wanted to make sure that there was no problems. But yet, defense counsel and the defendants mischaracterize it intentionally. They should be sanctioned for doing so. They mischaracterize these non-threats as threats in order to garner sympathy from the judge. Now, there was a second threat that was alleged in this motion. Maybe that one was actually a threat. Let's see. The second voicemail was from an unknown wireless caller and made offensive threats against Ciaba Green. Let's take a look at that one. Voicemail preview. You are a lying fat count. You are a liar and you are an expletive hunt. So I don't know about you, ladies and gentlemen, but when defense counsel is alleging in this emergency motion that these violent threats are taking place against Ruth Ciaba Green, that wasn't a threat either. Very vulgar response, I would say, but protected under the First Amendment, and more importantly, has nothing to do with me. I always advocate for peace, peacefully petitioning your grievances to your government for redress. Always been peaceful. Not only do I advocate for peace on this channel for the last 4 years, if you've been watching, you know that. I also have a disclaimer to be peaceful in the description, but more importantly, I'm not the one making these statements. These are people I do not know from across the country who happen to see my reporting on this grave injustice, this tyranny, and they are petitioning their grievances to their government. I would hope they do so peacefully. I would hope they do so professionally, but being vulgar is your First Amendment right, and I will always support everyone's First Amendment right. I do not support threats. I condemn them. And please do not send any threats to anyone mentioned in this video. I do not condone that. I actually condemn it, something that the New York State correctional officers cannot do when it comes to the vicious and merciless beating and murder of Robert Brooks. It goes on. Following receipt of these voicemails, Ciaba Green spoke to the Berwyn director of IT, who provided her with an increased method of security for her direct contact lines and showed Ciaba Green the cause of these renewed harassment attempts. programs. Reyes uploaded Ciaba Green's video deposition on February 4th, 2025 at around 10 a.m. in direct violation of the court order to his YouTube channel. Applicable standards. District courts may fashion an appropriate sanction for conduct which abuses the judicial process. Chambers v. NASCO, Inc. Sanctions may be imposed pursuant to rule, statute, or court's inherent authority. See Roadway Express, Inc. v. Viper. Well-acknowledged inherent power of a court to levy sanctions in response to abusive litigation practices. This is not abuse. This is me telling a story about your abuse against me. This is me, an independent journalist and activist, telling the world that government agents, including a city administrator and 3 law enforcement officers, conspired to violate my rights and put me in a jail cell. That's what this is. Sanctions imposed under the court's inherent authority are appropriate where a party has willfully abused the judicial process or otherwise conducted litigation in bad faith. A court, pursuant to its inherent authority, may impose appropriate sanctions to penalize and discourage misconduct. Further, a court has inherent authority to impose sanctions for litigation misconduct that involves, quote, bad faith designed to obstruct the judicial process or a violation of a court order. Argument. With respect to the inherent power to sanction, the Seventh Circuit has affirmed and approved of the use of this inherent power with respect to social media postings. The court has inherent authority to manage the judicial processing and regulate the conduct of Sean Paul Reyes. Pursuant to this authority, the court may impose sanctions to penalize and discourage the plaintiff's misconduct. Any sanctions imposed by the court must be based on a finding that the plaintiff willfully abused the judicial process or otherwise conducted the litigation in bad faith. The Seventh Circuit has upheld the court's inherent power to sanction with respect to social media postings. The Seventh Circuit in Emerson v. Dart found that the district court did not abuse its discretion when it sanctioned the plaintiff $17,000 for making a Facebook post threatening potential witnesses with legal action if they testified against her. So they cite to this case from 2018 where someone was making legal threats against witnesses and they were sanctioned $17,000. And they think that this case is analogous to my case, where I am simply exercising my freedom of speech. I am not defaming anybody. I am speaking the truth that is on video for the world to see, the truth that you all saw when you watched the deposition of the city administrator, Ruth Ciaba Green. The real reason they don't want you to see the video depositions isn't because of some fictional threats or embarrassment. It's because they know that when you watch the depositions, you will see them for what they truly are, and they don't want that. It goes on, the plaintiff argued that her Facebook post could be read fairly as an open call to the union members to testify truthfully, because she only threatened liars with legal action. The Seventh Circuit found that the plaintiff's argument unconvincing. Again, this case is not analogous to my case whatsoever. I am speaking truth to power, and I will never stop. Accordingly, the court held that the plaintiff's Facebook post merited sanctions as she targeted and publicly threatened potential witnesses. Again, I'm not threatening anyone. I'm not targeting anyone. I am talking about a case that involves me, an independent journalist. The video is clear. I did nothing wrong. Ruth Ciaba Green, the city administrator, testified in her deposition that I did not threaten her. I did not raise my voice, use profanity. The only thing is that I was recording peacefully, which is my First Amendment right. So again, I have nothing to hide here. They do. The motion goes on to say, with respect to the inherent powers to sanction, in this case, Reyes can be found to have acted in bad faith, prohibiting plaintiff from posting defendant and defense counsel's names, biographies, and phone/email contact info, along with the prohibiting and publishing of the case deposition due to the responsive and continuing phone and email harassment it caused throughout the proceedings have been the subject of multiple prior filings and in-court oral arguments. Public scrutiny of corrupt and tyrannical government officials is protected by the First Amendment, or at least it's supposed to be, but it is also paramount for we the people to publicly scrutinize our corrupt government officials in order to hold them accountable. The court ordered Reyes to refrain from posting the videotape depositions even after the civil proceedings ended because it was obviously clear that Reyes likely intended to misuse the footage for his own pecuniary gain. Again, another fancy word for my income, as well as to cause harassment to the defendants and their families. That's not true. I don't want anybody to be harassed. I want people to be held accountable. That's why I filed this federal lawsuit. That's why I fought the criminal charges against me when they were falsely placed on me. And how did I misuse the video deposition? All I did was publicly post it for the world to see. Ruth Ciaba Green's own behavior exposed her for what she is. The motion goes on to say, Reyes, within weeks of this court granting summary judgment, willfully, knowingly, and maliciously violated the court's order by posting the videotape deposition of Ciaba Green to his YouTube page. So I want to address it. My lawyer, as I said earlier, threw me under the bus. I am still looking for a new attorney to represent me in the state of Illinois in federal court. Again, email me if you are interested. I had a misunderstanding with my lawyer. We had a conversation after the case was dismissed. We were talking about the appeal. I brought up the video depositions. I apparently must have misunderstood, but I walked away from that conversation with my attorney thinking that it was okay, now that the case has been dismissed, for me to post the video deposition. While it was my genuine belief that the court order did not apply anymore, it is still a prior restraint on my speech. I'm being silenced. And again, I don't necessarily blame the judge. Judge Maria Valdez has only received negative reports about me. False allegations by the defense counsel, the Delgado Law Group, again, who represented Super Mayor Tiffany Henyard. They have portrayed me as the villain of this story. I'm the one who was falsely put in jail. I'm the one who had his freedom taken away from him, my property taken away from me as evidence of a non-crime. The motion goes on to read, his actions in line with his sustained pattern of contentious and abusive behavior were clearly meant to intimidate and harass while generating substantial amounts of income for himself. I'm going to address the income because obviously defense counsel has some sort of obsession with my income. He's mentioned it several times in this motion. I'm sure the defendants agree with him. That's why he put it in the motion. But my sustained pattern of contentious and abusive behavior. So for those of you who've seen the video deposition before I had to remove it the same day, you saw Ruth Ciaba Green's lawyer treating me with hostility. Even in my own deposition, defense counsel was extremely rude, unprofessional, and antagonistic. I have been nothing but cordial to defense counsel and the defendants, despite them all conspiring to violate my rights. The defense counsel using lawfare in order to silence me for these imaginary threats. These are imaginary threats. That was a photojournalist asking to take pictures in City Hall and didn't want any problems, and somebody who didn't like Ruth Ciaba Green and called her a bunch of names. Those aren't threats. Those aren't violent threats. This is free speech. We, the people, have free speech in this country, or at least we're supposed to. And by defense counsel using the federal court system in order to silence me and completely eliminating public scrutiny of government officials who are engaging in misconduct. So the only people in this case who have a sustained pattern of contentious and abusive behavior that was clearly meant to intimidate and harass is the defendants. Ruth Ciaba Green, City Administrator, Sergeant Volante, and Detective Monaco, and their defense counsel. The moment defense counsel and the defendants all do their jobs for free, then they have room to talk. Until then, they should stop trying to judge me and try and discredit me for generating income and worry about their own income. The motion goes on to say, pursuant to docket number 61 and pursuant to the court's inherent authority, Reyes must face sanctions for his failure to abide by the order. This court and these court proceedings do not exist for Reyes to harass, to entertain his followers, and to make money off social media posts. Reyes violated the order, he knows it, and he did it purposely to harass. They are all so blind for their hatred for me, transparency, the First Amendment, that they can't even see how ridiculous they sound. I am not trying to harass anybody. I put up a video of a deposition for the world to see because it's a city administrator lying under oath, saying things that aren't consistent with her previous statements. The world has a right to see that. The Berwyn residents and citizens across this country have a right to see government officials engaging in perjury and misconduct. I am reporting on facts that happened to me as an independent journalist and activist when I visited the City Hall in Berwyn. None of this is personal to me. This is about transparency and accountability for public servants. It's personal to them because they hate that I'm exposing them. Defense counsel hates that I make money doing what I do, talking about things he doesn't want me talking about. That is what angers them. The defendants and their lawyer hate that I have a platform, but I have a platform thanks to each and every one of you. We together built this platform, and now we're able to call out these tyrants to the world. The motion concludes with the following. Wherefore, the defendants respectfully request that the court A, enter an order requiring Reyes to immediately remove the above referenced video deposition of Ruth Ciaba Green from his YouTube channel and his website and any and all other internet forums to which he has posted the video. The judge has already done that. She has granted them preliminary relief and ordered me to take down the deposition, which is why I immediately complied and took it down. Judges have a lot of power and authority, and if I did not take it down, she could have held me in contempt of court. She could still sanction me. I don't know. Again, this is what happens when you deal with people with power who want to silence a journalist from speaking the truth about government officials' misconduct. B, enter an order prohibiting any future publication of the above referenced video deposition of Ruth Ciaba Green to Reyes' his YouTube channel, his website, and any other internet forums. C, enter an order prohibiting any future publication of the other video depositions taken in this matter to Reyes' his YouTube channel, his website, and any other internet forums. D, enter an order sanctioning Reyes to a financial penalty pursuant to the court's inherent power to sanction as an equitable and proportional sanction. E, enter an order awarding defendants costs to bring this action. So looks like Sean Sullivan with the Delgado Law Group here, he wants me to pay for his attorney's fees. That's what he's asking the court. He wants me to pay because he had to write this emergency motion because people were being threatened violently. Not true. Not true. The court should sanction the defense counsel, Sean Sullivan, because he's bringing this action in bad faith. He is bringing this action saying that people are being threatened and harassed. He said that previously, or at least the other attorney did, Cynthia Granfield, saying that this is harassment and there's violent threats being made. None of that is happening. They have no proof of it. They showed benign voicemails that Ruth Ciaba Green got of people peacefully petitioning their government for redress. That is not harassment. That's not violent threats. That is First Amendment protected activity. And finally, F, any further such relief that the court deems equitable and just. Respectfully submitted, defendants by Sean M. Sullivan. So Mr. Sullivan works for the Delgado Law Group. He is a senior partner there. Again, I told you that the Delgado Law Group represented the super corrupt Mayor Tiffany Henyard. They no longer represent Mayor Henyard because I think they saw the writing on the wall and they didn't want to go to prison as well. But I looked into this Mr. Sullivan. And again, this is public information. I do not want anybody to contact the Delgado Law Group. So when I received this emergency motion from Mr. Sullivan, I decided to look into him a little bit to see what kind of person he was, because I noticed that this was a very personal motion. He's talking about how much money I'm generating and that I'm contentious and I'm being willfully disobedient and that I'm threatening people, or at least people that watch my videos are threatening people, people that I don't know. So he took this a little personally. So I wanted to get a little bit about his background. And as I'm looking up Mr. Sullivan, I noticed on the Delgado website, right below Mr. Sullivan's profile picture in the area of expertise, the first thing he has listed is civil rights. My jaw almost dropped to the floor. This attorney who worked in the military, who's done a lot of accomplishments, and the number one accomplishment or area of expertise that he put was civil rights, while he is using lawfare to violate my constitutional right to free speech. He is advocating for a federal judge to issue a prior restraint preventing me from speaking and posting videos that are relevant to public scrutiny of public officials. These government employees, these public servants, need to be held accountable. I will be appealing this protective order to the Seventh Circuit Court of Appeals, and I will be appealing the summary judgment that was granted based on qualified immunity for the officers involved. That is my right, and that's what I will do. If you know an attorney in Illinois or you are an attorney in Illinois, please email me at longislandaudit@gmail.com. I need an attorney to represent me against these constitutional violations and to be able to fight against this defense counsel here, who obviously is mischaracterizing and embellishing the so-called threats in this case, which are benign and not threats, but they're actually speech that's protected by the First Amendment. Doesn't make any sense. I need somebody who's going to really fight for me. So if that's you, be sure to contact me. This is not personal. This is my job as an independent journalist. It is my job to report on these matters of public interest to each and every one of you. And my job as an activist to fight it every step of the way and to make sure that our government officials are held accountable for their misbehavior and misconduct. Stay tuned to the channel for any updates on this case and every other case that I'm dealing with right now. Thank you all for your support. It is genuinely and truly appreciated. As always, stay safe. God bless. I'll see you in the next one. Long Island Audit. Peace.